Hello. Today's topic is going to be really geared for people that have support obligations or people that are owed support. And with us is Brooke Mulligan.
Hello.
And we're going to talk about the Disentitlement Doctrine. This is a tool that we can use on occasion to go after people who are not paying their support, and there's huge consequences. Hey, Brooke, how are you?
I am well. How are you?
Good. We just have been working like crazy on our clients' cases. The summer's usually pretty busy for us. Mm-hmm. Are you taking any time to rest in between all the cases?
I'm using my rest time to do more fun things. So maybe in the fall I'll start resting a little.
That's because you're young. So there's no such thing as rest when you're young, right? Because if you're not here, like going 60 miles an hour on your time off, you're doing that too.
Exactly.
Okay. Well, what about the heat, though? I mean, we're in this historic heat. I feel like California's been warm, but it hasn't suffered as much as the rest of the country. But still, here we are, high 90s and all of that stuff. Is that impacting you at all?
It's not. Maybe it should. I complain maybe a little bit more, but I'm not stopping plans for anything. If anything, maybe I'm just seeking out more water-based activities.
Yeah. Well, cool. All right. Well, I'm glad to see that you're in one piece and you seem like in good spirits despite the heat. Today we're going to talk about an appellate court decision. What's the name?
Cohen v. Cohen.
Okay. And this is going to be interesting as it applies to our clients that have support obligations or people that are owed support, right?
Mm-hmm. Definitely.
Okay. Why don't you set up the facts for us and tell us all about this case?
Okay. So it is fact heavy. So bear with me. I want to be clear on everything. Our players are Richard and Laura Lynn. They were married from 1990 to 2006. And they had 4 children, all of whom have significant disabilities. Something interesting that is...
How many? There's like 4 kids?
4.
Okay.
All with significant disabilities. And something the case never gets into, and I wonder if it's at play, it's just not relevant, is if we're talking about adult child support at all. I did some, quick math, but if they had, a 4-year-old in 2006, assuming basically that's the old, in 2020 he's 18, he or she is 18, and we're still fighting. So I wonder if there's adult child support at play. But like I said, not exactly relevant here, just something to think about. So they are separated in 2006. In 2011, they file a stipulated judgment, which, among other things, I imagine, there was an agreement to have spousal support set at $15,000, and child support set at $13,200 a month.
Time to pause. That means, just looking at those numbers, what?
He's a high earner.
He's a very high earner. I mean, those numbers are not common for most people.
No.
So this dude has a lot of money, and he could pay support.
Definitely. 3 short years later, Richard files an RFO for a reduction in child support and spousal support. Actually, I believe it was to terminate spousal support. And in 2006...
So, wait. 3 years after he's ordered to pay spousal support for a long-term marriage, mm-hmm. he goes running into court whining that he shouldn't have to pay anymore.
Exactly.
I wanted to terminate. He's not asking for a reduction. He's asking for to terminate.
Yeah.
Okay, good luck with that guy. Okay, go ahead.
In 2016, on that same RFO, the court declined the request. And it appears that he actually appealed the ruling because the opinion that we're reading says this court affirmed. So it looks like this is at least his second time appealing a decision.
They're starting to get to know this guy.
Yes.
And we're talking about the Court of Appeal, which is unusual, but we do have some family law cases that it's kind of funny because it'll be like marriage of Smith 1, marriage of Smith 2, and I've seen some that are like 3, and then the appellate court starts chiming in like, oh, we're getting kind of tired of these people. But go ahead.
It's funny because there's not, family law is a little interesting when we don't have the most case law, compared to other practice areas.
Like criminal law. Yeah.
Right, because, these are families, and are you really going to take the time and money to appeal something? It happens less than I think it does in other practice areas, like I said, but not for Richard. In November 2018, there is a post-judgment stipulation. They agreed that Richard would need to pay $524,000 and some change to satisfy all the arrears. Future child support would be set at $10,500 a month, so that's about $3,000 less. and then they are going to go to trial for the issue of spousal support.
Okay, so let's kind of slow this down for the non-lawyers in the audience here. Richard's been a bad boy, or something's happened where he hasn't paid support to the extent that he's got arrears, meaning money owed to her, over $500,000.
Right.
Okay, now I don't know how in the world that lapsed. I mean, did he just forget to write the check every month or what? I mean, kind of ridiculous,
A little ridiculous.
So what we tell people is, look, dude, if you can't pay this, then you need to file a motion, get into court, and take care of this, because those arrears are going to continue and you can't get rid of them.
No.
It's your obligation to cry to the court early that you can't do. And he's already gone in, right? He's gone in and getting a stipulation to decrease it somewhat, 13,000 to 10,000 and stuff like that. So he owes $500,000, and he agrees to lower she agrees to lower the child support to $10,000 per month.
Correct.
And then they're going to take the spousal support issue to trial.
Right.
Again, this is only after 3 years.
Right. No. This is November 2018, so it's now 7 years.
Okay, but he's probably still being unrealistic. It's a long-term marriage with minor children. Chances are the court's going to say, look, I feel your pain, but you know what, you got some obligations here. Okay.
One thing we also should point out for our viewers is that those arrears, also there's going to be some interest. It's very bad not to make your child support payments, but what really gets you is going to be that 10% legal interest. So
not dischargeable in bankruptcy.
No, you are on the hook. So the court used some interesting language, saying that the parties agreed a trial would be held before Commissioner Vogel
Oh God.
So is that
Commissioner Vogel? I know him.
I know him. That was what I was keeping
You know
from
him.
Yes, I worked with him at the Veterans Legal Institute. We did a family law clinic, and he was one of the. This is when I was in law school, so I was just helping. But he was one of the great people to come and volunteer.
It's amazing that we both know him. So he might remember me. I don't know. But when I was a brand new attorney in the DA's office in Orange County, I was first assigned to the family support unit. And he was one of two commissioners that did all the family law cases. And he really knew what he was doing. And he was in that assignment for years. And now we know that he's retired. And in this case, he's sitting on assignment, it sounds like. So he's kind of like getting paid to come back and help out, right?
Exactly.
But he's still got his wits with him. He's smart. He knows family law.
He's smart. They speak of him fondly in this opinion.
Yeah.
They're not overruling him.
Yeah.
So in February 2019, they have Commissioner Vogel gives a tentative decision reducing spousal support to about $10,000, but that is not the final order. And then in March 2019, Richard files an RFO to reduce child support to guideline and terminate spousal support from the November 2018 stipulation. So it's a little confusing because Richard seems to be kind of crossing a lot of, things here, because he still has the trial before Commissioner Vogel.
This is private judging, by the way, or is it?
Well, that's what I was a little confused on, because it didn't say that they were sent to, for example, a mandatory settlement conference. But then later on, after Commissioner Vogel does, his rulings, he then grants the case to go back to public court.
Yeah, I think what happened is they stipulated to private judging is the way that I read this. So Commissioner Vogel is. I got it wrong. He's not helping out with the court. What he's doing is he's on assignment for some, like ARC or Signature, one of the groups and stuff, and he's being paid as a private judge, which is much more efficient for people, he's definitely qualified. The way that I read that part of it you're talking about is that while they're pending his tentative decision to become the decision, he goes and files another motion.
Exactly.
He says things have changed even since then.
Right.
Okay.
So that's March 2019. And then he stated within his declaration that the income available for support was I'm sorry, such a big number. It was $66,000 a month in November 2018, which is when they entered into the not updated stipulated judgment, but the post-judgment stipulation. But he was going to be terminated on March 15th, 2019, and his income would then only be $18,000 a month. So Laura Lynn files a motion to dismiss the RFO under the Disentitlement Doctrine because Richard has not paid any spousal support since October 2018 and was late for February 2019 child support and had not paid March nor April 2019 child support.
Okay, so
So
let's
we're
kind
throwing a lot of...
Yeah, let's clarify this. As I remember the decision is that he was faced with contempt charges at one point.
That's coming up.
Yeah. Oh, it was like, okay, well, originally what he did is he caught up in his support in order to get a modification downward because she had, that type of thing, right?
Kind of, right.
Okay.
So there's a lot of different proceedings going on and kind of in quick succession with a lot of overlap. So it's easy to get confused.
And they got stuff in California and New York because he's reporting his income different depending on where
places,
he's at,
right? So Richard opposes the motion to dismiss, saying he doesn't have the ability to pay, and he had to borrow $500,000 to pay arrears. We then get the final statement of decision in April 2019. Commissioner Vogel reduces spousal support to $8,000, leaves child support where it is, which I think he almost couldn't have made a ruling because per the November 2018 stipulation, the trial with Commissioner Vogel was just on spousal support. So maybe just by staying quiet, they're saying that's a ruling, but nothing changed. And then he determined arrears for October 2018.
Well, I think he was in front of Vogel twice. There was a first bite in the apple, and then they went back to him, is what happened, as I understand it. And that second time around, as he was deciding, he was making he made a tentative decision. And during that period before it became final, the husband then files a request to terminate spousal support again. Now Vogel doesn't take that one on. He makes his final ruling, releases it, goes back into the public domain, and meanwhile, between that time and when they're in family court now, husband is making all kinds of representations of what his income is. Mm-hmm. In New York, his attorney says he's earning, I think, like $300,000 a year. His attorney in California is saying $200,000. I mean, it's all over the board.
It's confusing.
So now we have this pending modification in family court, and wife says, wait, you shouldn't be able to seek this at all because the disentitlement doctrine, you weren't paying when you could pay, and you intentionally didn't pay, right?
Exactly. So he's racking up further arrears. Mm-hmm. She was able to get some via wage garnishment and bank levy. It was less than $10,000. She's working hard to get this money. And then Richard files an objection to her motion to dismiss in May 2021. And he says that his non-payment was not caused by willful disobedience, but simply because he had an inability to comply because of lack of income. And we know that contempt, you need to show a willful disobedience. So he's fighting back on that. And then May 14th, 2021, the motion to dismiss is heard. The court issues a tentative granting the motion to dismiss without prejudice to Richard, filing a future RFO retroactive to the date of the new RFO. So that wording is a little confusing perhaps for our viewers. When you file an RFO, you can argue that any order made, especially when it comes to I guess it really only works for support payments because you couldn't do custody back to... No,
it doesn't work that way. But it's usually for support. Yeah.
Usually for support, retroactive to the date of filing. So, for example, if you filed on August 1st, 2023, but you're not heard until mid-September, the court could order that the modification that they make be retroactive to August 1st. You may need to pay a little bit more, or you may get paid a little bit less, depending on the order. So back to the May 14th, 2021 hearing when the motion to dismiss is being heard. Laura Lynn confirms that her motion to dismiss was based on the unclean hands doctrine. And Richard's attorney, argues that it would be a complete injustice to make him pay since he lost his job in 2019, asks for an evidentiary hearing to present evidence that his monthly income over the last 2 years was $10,000 or less, and that he has no assets to pay the support. But the court, very smartly gets Richard's attorney to confirm that Richard has filed 2 income and expense declarations previously in the matter. And that brings us to finances, which you touched on. April 2019, Richard files an INE saying that he is working for a new company. This is the company that he said he was going to make, $15,000 down from $66,000. But it turns out he was making $20,500, which is still a big step down. However, his average monthly income on that income and expense declaration was that $66,000 because it's for the 12 months prior. He listed his expenses at $35,000, a little over $35,000.
Let me just say this: when we're talking about those monthly average income, that correlates directly to his ability to pay the payments he didn't make.
Exactly.
Right. I mean, he might have had a change now, but what about all those months prior where he was earning $60,000+ per month?
Right.
Right. I mean, the judge took note of that. Said those was your average. So why wasn't support being paid during those months?
I know we don't. The case is less concerned with the arrears that accumulated into the over $500,000, but I would love to see the income and expense declarations there, and whatever arguments he might have made about not making that money, because I believe he was still making the $66,000 during that time. In March 2020, as Dawn referred to, there was a New York legal matter, and Richard stated that his income was approximately $300,000 a year. In June 2020, so that's just 2 months later, Richard's family law attorney, so back in California, states that his income was a little over $16,000 a month, which is the $200,000 a year. And then in October 2020, Richard files another income and expense declaration stating his gross monthly income was $15,000 and monthly expenses were $40,000. So we're getting a lot of different numbers.
Right. He's making it up as he goes along.
Yes.
But the point is, though, he's got income.
He's got income.
Yeah.
And he's spending money. If you can spend that money on those expenses, you can.
Yeah.
So back to the motion to dismiss. The court dismisses, like the tentative said it would, and it denies the request for an evidentiary hearing, saying it's plainly obvious that he, Richard, has the ability to pay. Once he faced the OSC recontempt, he came up with the money. Look at the INEs, and it says he could have paid, but he chose not to.
So the court makes a factual finding that Richard had the ability to pay, and that he really, I don't know if the next part of this but that he intentionally didn't pay.
Yes.
So
they have a nice little zinger. That he chose to pay other things is not an explanation that's acceptable with regards to the unclean hands doctrine. And then July 3rd, 2021, they enter the order dismissing without prejudice with leave to file a future RFO for modification with retroactive effect preserved only back to the date of such a future filing. And this is the important part, so this is the bold, and provided that at the time of such future filing, Richard is current in payment of his child and spousal support obligations. Essentially, the court is putting a requirement that for Richard to come back to file an RFO, he needs to be current in his child and spousal support obligations. So that's paying all the arrears, everything that he hasn't paid previously.
No, that's in front of Judge Don Gaffney. I worked with him in the DA's office, so I think he might have been in the child support unit too. I'm not sure, but I think he might have. But interesting, he's now presiding over family court.
Mm-hmm. So this comes to appeal, all that background for the appeal, where the court decides basically the trial court was correct in dismissing the RFO. They did not have to do the evidentiary the evidentiary hearing, and they did say that the court had erred in putting that requirement on Richard to file a future RFO.
Judge went a little too far.
And I understand why. I like it, though. I wish the courts could do that. It would be very helpful, but it is too far.
Well, think about this logically, though. If he says, I want to file a motion, it's almost prejudging, what's happening, in the future as far as his ability to pay and his intentions and stuff. So I could see why the Court of Appeal made that decision. But ultimately, at least for the time being, sir, you are not going to get a downward modification. Yeah. Nothing's going to happen to your support, and it's all based on the fact that you intentionally chose not to pay your support payments when you had the ability to do so. Exactly.
But it is interesting because the ultimate decision it's not lackluster, by anyone's fault. It's just like, yes, that makes sense, and it's not necessarily any interesting thinking. It's just kind of common sense. It makes sense, but I think what is interesting is, like you're saying, how does this, how do we prepare our clients for this in the future?
Yeah.
What does it mean?
Yeah, I think another way of saying this is, why did the Court of Appeal publish this when you're kind of reciting current law that's been already addressed. The disentitlement doctrine is not new. There's been other decisions concerning this and stuff. Why was it published? Well, it seems to me it was published because Gaffney had gone a little too far and was talking about future. But having said that, I think that for our discussion, for our viewers, it's important because we could talk about something that a lot of people don't know about. In fact, I didn't know about this doctrine until fairly recently, and I was really interested in looking at its application. So if you have a client that comes to you and says, I want a downward modification, and that person has arrears, I think you have to say, well, let's talk about whether or not the court's going to get that to you until you satisfy those arrears or what, because there's some real danger here. And it's very, very rarely applied. I've never had it applied successfully against one of my clients. I had one case where somebody was claiming this, but it didn't really apply and stuff. But I have a case right now where the client has some small arrears, and it's a fairly recently filed divorce. There's some support payment that's owed. He wants a downward modification, and it's like, if I file that, what is the other side going to do? I know for me, this is a good way to represent your client, right?
Definitely. It is really interesting because, well, as the court does discuss the disentitlement doctrine at length, and really hammers home that it is the court has the discretion to use it. But it needs to be used
as a last resort. Does it say that?
I don't think it says exactly last resort, but I think they may have said lightly or case by. They definitely say on a case by case basis.
Yeah.
And I think when they say that, they don't even just mean this case versus. I think they mean in this particular case, every time you need to be looking at it.
You can't throw a blanket. Hey, you're precluded from ever getting a downward modification.
And it makes sense because if you kind of think it through a little bit. So let's say, I can't make payments, arrears are stacking up, I really can't make the payments, so I want to go in and modify my obligation. If you're assigning this blanket disentitlement doctrine, I'm just getting worse and worse and further in arrears because I can never modify it. And it's circular. It's circular.
Yeah, I think the way that you would counsel your client is say, look, let's make some payments, even if it's not the full amount. Let's do the best you can for a period of time, so that when we go back into court, you're not having unclean hands.
Exactly.
You've tried. You could say, yeah, I goofed up over there, but I've tried my best, because this is a court of equity, and the court, in fairness, should make a ruling on this issue one way or the other, right?
And I think that would have gone a long way in this court. They spend a fair amount of time saying, he had money to make payments. They're not even saying to make the full payments. They're saying you had money. You could have been paying towards your obligations. When he was about to be faced with the contempt, he was able to come up with that money real quick and, make that payment.
That was evidence of what was going on there.
Money was there. Who are you trying to fool?
I had this one case. We started criminally prosecuting deadbeat dads in Orange County when I was in the family support unit. And one of my colleagues argued to the jury, he didn't even buy him a Happy Meal. Not even a Happy Meal, Yeah. I think that's what the Court of Appeal, is kind of looking at. Dude, you didn't even make any effort. I mean, you just let that support obligation run out of meanness, right?
Right. Yeah, I had not heard of the disentitlement doctrine before. It's very interesting, and I think you can definitely use it. But I think for all attorneys out there who want to use it, you need to be nuanced and, really specific. It can't be enough to just say, he's not...
You missed a couple payments.
Yeah, I think it needs to be very thoughtful. Another thing that the court spent time on was the evidentiary hearing, which is something that we have a lot in our cases. So they basically... Richard was arguing that because the trial court hadn't given him the evidentiary hearing he wanted, they had erred, and essentially it's a reversible error, and it needs to be done. And I thought the Court of Appeals was very strong in saying, you kind of forfeited your right to that by not specifically asking for the evidentiary hearing. Apparently, no one brought it up during the proceeding. I guess his attorney was just saying, I want to show that this isn't right. There was no talk of cross-examining, and the court had had the information it needed. It had the declarations from Laura Lynn, it had Richard's declarations and income and expense declaration, and then it also had the inferences that could be drawn from it. But they did spend a lot of time saying that he forfeited his right, and I think that's something that we should all be aware of. If you want that hearing, you need to, express that. I don't know if it would have been enough in this case. I don't think so, given everything else.
Well, what it said was, even if we're wrong, it was harmless error.
It's a harmless error.
Which I thought was interesting, that they're kind of got one eye up on the California Supremes and saying, if we were wrong, it's harmless error. But, I think that, you have to make it really clear to the court. That's why what we do is if we want an evidentiary hearing, even if there's only two parties, right, that are going to testify, husband and wife, we make our request in writing.
Definitely.
Right? And we have, a witness list and everything ready to go to make it really clear what we're asking for. A lot of people don't remember that Family Code Section 217 has rules, and if you're going to ask for an evidentiary hearing, you probably should take a look at that code.
Yes, yeah. It's decently specific.
Yeah, and in a case, in fairness to the court, if you're dealing with an issue of arrears and ability to pay, you're looking at a long cause matter. You're looking at something that's probably more than a day, because this guy's going to be going and cross-examining your client and putting on all kinds of evidence, and the judge has to juggle that trial with everything else that's got on calendar. And boy, how that must feel when there's a surprise. He's thinking that he's going to rule just on the pleadings, and suddenly somebody's demanding their trial. So you could see the court's point of view there, and I think that it just behooves people to say, you know what, Judge, I want this, and maybe we could even pick some dates or send us down the hall to somebody else.
I think that would go a long way. Not so much in this case, though, because I do think arrears are somewhat straightforward, and
well, ability to pay. It wouldn't take too long, right?
Right, exactly.
Because you just have to introduce those INEs, which are already in evidence.
Right.
So why would you need anything more?
That was something else that they talked about. Richard's attorneys never objected to the inclusion of the income and expense declarations. And I actually had a question for you. If you wanted to object to your own income and expense declaration, how would you do that?
Yeah, that would sound pretty ridiculous,
right?
I think.
Yeah, I think it shows that you really need to take those income and expense declarations seriously.
Yeah.
I don't know why you wouldn't, but if you were thinking about maybe not.
Well, what happens sometimes is that some law firms, they fill out the income and expense declarations, and they don't really sit down with the client before the client signs it. And there's some errors on there, like their expenses exceed their income, but there's no credit card, no debt that's owed, and it just doesn't make sense, and stuff. And they don't think about that, and then they regret it afterwards. And, of course, when the person takes the stand, they blame it on their attorney.
Exactly.
And stuff. But, yeah.
When I was clerking, income and expense declarations were something I did a lot of, and I learned a lot from our paralegals. And one of the best pieces of advice I got was, to use some common sense. It's easy to get bogged down in the numbers, and you see, here's the bill. Okay, I'll just put it in. But then take a step back and really look at it holistically. Looking at the expenses versus the income coming in is a great. It's kind of a catch-all for me. And every time I see that, I ask my client, well, how are you making these payments? How are you?
Yeah, I look at income and expense declarations as a tool that was created to give attorneys the opportunity of cross-examining. That's all it's there for, is to show the other side's not being truthful. And there's lots of ways to do that by looking at it, right? So, what we tell our clients is, you're going to get hurt if you're not truthful. If you're truthful, then you're fine. And we're going to sit down there. We're going to make sure you understand it and stuff, yeah. Brooke, one of the things I thought is, besides the this doctrine, the disentitlement doctrine, what else can an attorney do for their client when they're going after somebody that owes arrears?
Well, there are the wage garnishments, bank levies, which is something I think we all know you can do, but I don't know how often it's actually done. So it's good to do that. And then I think I would also, if my client wasn't being paid, I'd be sending a lot of letters. Even if the outcome, even if I don't believe we're going to get anything out of it, that is great evidence to show, awareness.
Meet and confer. Yeah, I think for attorney's fees, because we know that for contempt, there's a prevailing party fee award. I think that you can ask for sanctions in certain circumstances. There's a lot of other tools that are in the toolbox besides the disentitlement doctrine. But it's nice to know that we have this one too, and I have a feeling that when more people become aware of this, we're going to see a lot more. Hopefully, it will be applied appropriately. But it's a good one. I mean, I'm all about making people take care of their obligations, and I hate to see somebody like hurting kids like the way that this guy was doing before this judge held his feet to the fire, right?
Well, and remember, these are not just minor children, which is very
Special
sad.
needs
They're
kids.
special needs.
Yeah.
And this woman, I mean, how often
How
was she in
mean.
court?
Yeah. Okay. Well, thank you very much.
Of
This
course.
was wonderful. I hope that you enjoyed it, and we'll see you next time on Exhibit A.